The information presented in this video is the proverbial tip of the iceberg regarding Oregon government, corporate, and private law firm conspiratorial corruption. This small, steaming spoonful of corruption will leave you with a foul taste in your mouth that you won't be able to rid yourself of because it is affecting you, your family, your friends, everyone. Your health is a commodity that is bought and sold, traded for profit and loss. If you or someone in your family become a medical liability to corporate profits, then you are tossed to the side of the road. The U.S. healthcare system has evolved into a parasite. Sleazy companies and state government game the system and steal from the taxpayers of this country. As always, we the little people are the losers. Remember, corporations are there to maximize profits with government assistance and are beholden to shareholders, not to us or our well-being. Government corruption is metastatic throughout our country. It has affected elected and unelected public servants, the courts, government and private lawyers, law enforcement, public and private institutions, etc. This cancer is killing us. Maybe this presentation will encourage others to bravely step forward with information. There is much rotten Oregon government, and it all needs to be exposed. After viewing this video, you will have no excuses for not addressing these problems. If you do nothing, you put yourself, family, friends, and the entire lot of us at substantial risk for medical mismanagement, all of which is based upon the almighty altar of profit. Some of you viewing this video will be resigning from your positions of power. Some of you will hopefully be going to prison for manslaughter, extortion, fraud, and more. The whistleblower worked for Agate Resources, Trillium Health, from November 7, 2005 to September 27, 2013. His title was Data Warehouse Administrator for Trillium Community Health Plan. The whistleblower worked in the Information Technology Department as the lead database administrator, programmer, web page management, and medical coding expert. The whistleblower installed and customized medical management and analysis software. These tasks required access to company and patient records. Additionally, the whistleblower saw in real time what was transpiring at Agate Resources, Trillium Health, and their shell companies on his work computer. The whistleblower is a very accomplished computer engineer and has been involved with a number of important projects over the years with companies such as Honeywell, Tektronix, and Spectra Physics. The whistleblower is also certified in and quite accomplished at medical coding, which is necessary for medical billing. You take this improbable combination of knowledge and combine that with a man of integrity, honesty, and humility, and you have a formidable opponent, which the whistleblower has been. He has an immense strength that he derives from his spiritual bearings. Explicit death threats have been made to the whistleblower and his family. The Oregon government and corporate syndicate have attempted to kill the whistleblower by withholding medical care and unemployment benefits due to him. There have been other Agate Resources, Trillium Health whistleblowers, and each has been attacked by Stoll Reeves, a Portland-based law firm, to the point of professional, financial, and personal ruination. Stoll Reeves used fictitious and altered documents as a common scheme to achieve this. Thus, many whistleblowers have been unwilling to step forward once they have witnessed the destruction of their co-workers' lives. John Kitzhaber was first elected to the governor's office in 1995 and served 2 terms up through 2003. Kitzhaber was re-elected as governor in November 2010 and served his 3rd term from 2011 through 2014. Kitzhaber was sworn in for a 4th term as governor January 12, 2015. By this time, it was clear to Dr. Kitzhaber that he was in some serious trouble. He had not been honest with himself nor the public as to his criminal misadventures as Oregon governor. The whistleblower reported ethics and legal violations by Kitzhaber and his aides to the Oregon Ethics Commission and Portland U.S. Department of Justice, December 18, 2014, along with documents to corroborate his allegations. Oregon media ignored the whistleblowers, who came to them with information about criminal acts by John Kitzhaber and the coordinated care organizations administering Medicaid and Medicare dollars within the state. According to the whistleblower, in January 2014, multiple whistleblowers became aware that Governor Kitzhaber's aides were soliciting money from Agate Resources, Trillium Health, and that Kitzhaber himself was apparently involved with a number of illegal scandals regarding Medicaid dollars set aside for the most financially vulnerable in Oregon. These illegal activities were in addition to Kitzhaber's girlfriend, Sylvia Hayes, selling access to the governor's office for clean energy nonprofits, which is what the public was being fed by the Oregon media. According to the whistleblower, Sylvia Hayes was lobbying for Agate Resources, Trillium Health. Another lobbyist for Agate Resources, Trillium Health, was Kristen Leonard, the wife of Kitzhaber's number 2 man for his election campaign, Kevin Neely. Kristen Leonard was working full-time for the Port of Portland while lobbying for Trillium Health. She went on to become Kate Brown's chief of staff before being forced to resign over conflicts of interest and ethics violations involving her and her husband's business of, quote, assisting, unquote, political campaigns. On February 13, 2015, facing a federal criminal investigation, Kitzhaber announced his intention to resign as governor effective February 18, 2015. Secretary of State Kate Brown succeeded him upon his resignation. Dr. Kitzhaber was investigated for over 2 years, but in 2017, the federal government dropped its investigation without filing criminal charges, to the shock and dismay of many Oregon constituents. After the federal investigation was closed, the Oregon Ethics Commission found 10 instances where Kitzhaber used his political office for personal gain. He agreed to pay a fine of $20,000. He never served any time incarcerated. Kitzhaber's campaign official, Kevin Neely, and Neely's wife, Kristen Leonard, were reportedly the go-between involved in Kitzhaber's illegal solicitation scam. Governor Kitzhaber was reportedly given $40,000 by Agate Resources Trillium Health executives at a meeting in Salem, Oregon, in return for his participation in the destruction of any Agate Resources Trillium Health whistleblowers. The whistleblower has copies of the original records that substantiate this sum of money. The $40,000 was eventually explained away as a campaign contribution discrepancy after the whistleblower filed a complaint about this crime to the Bureau of Labor and Industry, BOLI. The $40,000 in cash given to Governor Kitzhaber in January 2014 suddenly showed up as campaign contributions in May 2014. These brave whistleblowers, what I would call heroes, stepped forward regarding Governor Kitzhaber's and Agate Resources Trillium Health's criminal misconduct. The whistleblowers were in contact with the U.S. Department of Justice, U.S. Department of Health and Human Services, U.S. Department of Labor, and the FBI. These heroes have suffered greatly for their whistleblowing, while government and corporate criminals have prospered. Kitzhaber walked away with a battered ego and a relatively small fine for his egregious acts, such as accepting payment for political favor, selling access to his office, and turning a blind eye to criminal corporate and government misconduct. No government bureaucrats, physicians, or corporate players suffered any personal consequences for being intimately involved with these unlawful acts. In fact, most received promotions and more money. Kitzhaber's constituents were severely financially, psychologically, and medically harmed, resulting in many deaths as a result of his callous decisions made purely for his personal financial benefit. Oregon government is rated as one of the worst in the United States by the Integrity Project. Oregon gets an F grade. Amanda Marshall was a United States attorney and top federal prosecutor in the Oregon United States District Court. She was tasked with investigating Governor Kitzhaber until she resigned her position abruptly April 24, 2015, amid an internal review. She cited unspecified health reasons as the reason for her resignation, but in reality, her resignation was the result of sexual improprieties with a subordinate male U.S. Marshal, along with drug and alcohol abuse. Some feel Amanda Marshall's removal was politically motivated, the result of her subpoenas of Kitzhaber, Trillium Health, and others. Oregon Attorney General Ellen Rosenblum refused to release these subpoenaed records. It seems strange that a state attorney general will go to such lengths to cover up criminal acts and impede a federal investigation. The only rational reason for this, it seems, is that Attorney General Rosenblum was ultimately protecting herself from further scrutiny, as will be covered. Attorney General Rosenblum is eyeball deep in the Oregon state sewage and has been for some time. Rosenblum seemingly used the weight of her position at the Oregon Department of Justice, along with the national law firm Stoll Reeves, headquartered in Portland, Oregon, to sidetrack the Kitzhaber investigation and to protect herself and others for their misdeeds. It is public knowledge that Rosenblum and Brown give out state contracts in return for kickbacks. Neither has any intention of changing that loophole. Once Miss Marshall resigned in disgrace, a Mr. Billy J. Williams was immediately appointed in May 2015 to her position by the Eugene Federal Court Judge Ann Aiken. This was an extremely irregular appointment. Later, in December 2015, U.S. Attorney General Loretta Lynch confirmed Mr. Williams' appointment. Once Mr. Billy J. Williams was appointed as a top federal attorney in Oregon, the Kitzhaber investigation by the FBI and U.S. Marshal's Office was ended. Oregon Federal District Court Judge Ann Aiken then sealed all records involved with the Kitzhaber investigation. This certainly smells suspicious for a quid pro quo deal between Judge Aiken and Billy J. Williams. The whistleblower contacted Attorney General Hardy Meyer's office in 2007 with information about the illegal selling of employees and their families' medical records and costs by Agate Resources Trillium Health to private entities. The whistleblower provided documents verifying the sale of employees and their dependents' medical costs and records by Agate Resources Trillium Health to private companies and individuals. The whistleblower spoke with an attorney at Attorney General Meyer's office who told the whistleblower that the sale of these records to an employer was legal in Oregon. The whistleblower did not trust the attorney's answer, so he contacted Centers for Medicare and Medicaid Services, also known as CMS, to get another opinion. CMS told the whistleblower that these were HIPAA violations and that each instance was an automatic $55,000 fine. The whistleblower turned over the records of 28,000 employees from various Oregon companies, along with about double that many dependents' records, to Attorney General Meyer's office, so around 84,000 records in total. If only one violation occurred for each life, that would equate to $4.6 billion in fines alone. Attorney General Hardy Meyer did nothing with this damning information. The whistleblower contacted Attorney General John Kroger's office in 2009. His office was given the same information as Attorney General Hardy's was given. Attorney General Kroger did nothing with this damning information. Attorney General Kroger resigned suddenly 3.5 years into his term, supposedly for health problems, but a few months later ends up as president of Lewis and Clark Law School. The whistleblower had direct personal contact with Secretary of State Kate Brown twice in February 2012 and once in February 2014. During this time, Secretary Brown and her audit division were given damning documents on multiple occasions by the whistleblower which substantiated his allegations regarding Agate Resources' Trillium Health sale, not only of their clients' medical records, but also medical information that they had purchased from the Oregon Health Authority for foster children, prisoners, mental health patients, etc. Kate Brown's interest in these scandals and criminal acts was minimal to begin with, but her interest disappeared completely after Governor Kitzhaber resigned and she stepped into the position of governor. The whistleblower had phone conversations with Attorney General Ellen Rosenblum's staff on multiple occasions regarding Agate Resources' Trillium Health. Documents were hand-delivered to the Attorney General's office by the whistleblower in 2013, 2014, 2015, and 2016. In 2014, the whistleblower sent the Oregon Department of Justice documents indicating over $400 million in recoverable fraud perpetrated by Agate Resources' Trillium Health. Attorney General Rosenblum and her staff have shown no interest and have been completely silent regarding the whistleblower's allegations and corroborating documents. Attorney General Rosenblum has taken steps to actively block this information from being made known to the public, including intercepting mailings to courts and withholding their information. The whistleblower contacted Representative Mr. Michael McLean multiple times during his tenure as Republican leader of the Oregon State House during the 2012 to 2015 time period with information and supporting documents regarding Agate Resources' Trillium Health's criminal acts. Of interest is that he was appointed as a judge to the 22nd Circuit Court of Oregon by Democratic Governor Kate Brown in July 2019 while still serving as a state representative. Mr. McLean did nothing with the damning information of unlawful and felonious acts provided to him by the whistleblower. Mr. McLean worked for Stoll Reeves and Miller Nash law firms in the past. Michael McLean purports to stand with the children, just not the OHP kids, I guess, especially if they get in the way of a judicial appointment and money. The whistleblower contacted Senator Ron Wyden's Eugene staff and provided them with documents in 2013 and 2014 regarding Agate Resources' Trillium Health. Yet Wyden and his staff have done nothing with this criminal information. My personal experience with Wyden on two different occasions has been no different. I call it the Wyden shuck and jive show. Wyden acts interested, but then passes you off to one of his staff members who collects information about your concerns, and then you never hear back from anyone. The whistleblower contacted Senator Jeff Merkley's Eugene office in 2013 and gave them the same documents Senator Wyden received. The whistleblower spoke with Merkley's chief of staff, Gene Atkins, who recorded their conversation, for over an hour, August 25, 2014. Merkley and his staff have subsequently done nothing with this criminal information. Of interest, Gene Atkins was appointed Secretary of State March 2015 by Kate Brown once she moved into the governorship. Ms. Atkins has done nothing with this critical information. The whistleblower contacted Secretary of State Dennis Richardson in 2017 after he'd been elected in November 2016. On one occasion, the two spoke for 3+ hours. Secretary Richardson was given documents to substantiate the whistleblower's allegations regarding Agate Resources' Trillium Health's criminal schemes. Secretary Richardson hired a private auditing firm to verify all records and to interview the whistleblower. Richardson had his audit division investigate the Oregon Health Authority in 2017 for hundreds of millions of dollars of unaccounted for OHP money and the whistleblower's concerns. The audit results were published November 2017. Attorney General Rosenblum and Governor Brown made every effort to interrupt Secretary Richardson's audit investigation, even calling it partisan, even though Richardson was a man that was known for routinely working with Democrats and making bridges across the aisle as a state rep for 12 years. This damning audit report was given to Governor Kate Brown and other state agencies in November 2017. Secretary Richardson contacted Attorney General Rosenblum about these concerns. She promised to prosecute Trillium Health. In May 2018, Secretary Richardson was diagnosed with brain cancer. Once Richardson's brain cancer rendered him incapable of continuing his investigation, Attorney General Rosenblum dropped the entire thing. Secretary of State Dennis Richardson died of his brain cancer February 26, 2019. His death most likely pleased Governor Brown and Attorney General Rosenblum because Richardson was exposing their corruption at a number of different levels. Terry Copeland was the owner and CEO of Agate Resources and its myriad of shell companies. He was the brains behind Agate Resources' corruption, collusion, and criminal acts. Dr. Thomas Wiest, an orthopedic surgeon in Eugene, Oregon, was part owner of Agate Resources. He was also part owner and president of Trillium Health, Slocum Orthopedic Clinic, and other Agate Resources shell companies such as LIPA, Lane County Independent Physicians Association. He became the medical director of Trillium Health prior to the Centene sale and still currently holds that extremely lucrative position. Agate Resources was simply a holding company for over 30 shell companies such as you see on the screen: Trillium Healthcare, Lane County Independent Physicians Association, Lane Home Medical, and a number of other shell companies, including probable offshore companies and bank accounts. Trillium Health is a coordinated care organization, a CCO, one of 16 in 2015 that operated within the state of Oregon. There are currently 15 CCOs operating in Oregon. This insurance structure is called capitated healthcare. A specific amount of money is paid up front for each patient life, and whatever money is left at the end of the year is kept by the entity receiving and administering these funds. CCOs are simply claim processors. They receive claims from providers in their region, vet the claims, and pay them. Since around 2005, the CCOs became involved in benefits management, where they approve or disapprove of a service. Once CCOs became involved in benefits management, most assembled and operate shell companies that sell durable medical equipment, prescription drugs, home visits, feeding apparatuses, and a myriad of other ancillary medical services. The whistleblower has documents showing the shell company listed as the vendor, prescriber, and referring provider for their clients. These are all violations of federal laws prohibiting a doctor from referring a patient to themselves, partner, or business associate for services. This is a brazen rejection of Stark laws enacted in 1989. Here we have a simplified model of how a coordinated care organization is integrated into the Medicaid, Oregon Health Plan, capitated health care system. A capitated arrangement is such that a certain amount of money is available each month for each life. At the time, it was $650 per month per life. The Oregon Health Authority, the coordinated care organizations, and healthcare providers were all involved in this insurance arrangement, which put the coordinated care organizations in a particularly powerful position. Once coordinated care organizations became benefit managers, they formed shell companies which billed Trillium Health for real and fictitious patients and charges. The insurance money paid to the shell company ended up in Agate Resources, Trillium Health's pockets, because they owned the shell company. Salem government, such as Attorney General Rosenblum and the Oregon Health Authority, are quite aware of these illegal schemes, but do nothing to remedy the situation. They have placed Oregon in jeopardy for federal and patient investigations and lawsuits for ignoring the illegal and amoral actions of an Oregon public corporation. The Stark Law is a healthcare fraud and abuse law that prohibits physicians from referring patients for certain designated health services paid for by Medicaid and Medicare to any entity in which they have a financial relationship. The federal government interprets the term financial relationship broadly to include any direct or indirect ownership or investment interest by the referring physician, as well as any financial interests held by any of the physician's immediate family members. Stark law violations can result in penalties of up to $15,000 for each billed service that is based on a prohibited referral, plus 3 times the amount of the government overpayment. The Stark Law is a strict liability statute, meaning that proof of a physician's specific intent to violate the law is not required. Therefore, physicians who make prohibited referrals for designated health services, even accidentally or unknowingly, will still be subject to civil penalties. Physicians who are found to have knowingly and intentionally violated the Stark Law may be subject to increased penalties in the form of an imposed period of debarment or exclusion from participation in Medicare, Medicaid, and all other federal plans and programs that provide health benefits. Trillium Health processes and pays bills submitted by physicians, hospitals, and other associated patient health service businesses, in particular for Medicaid and Medicare insured patients. Many of the bills Trillium Health processes originate from their own shell companies that provide medications, durable medical equipment, and other medical supplies and services. Looking at the Excel spreadsheets for Lane Home Medical, we see significant concerns. Lane Home Medical was a shell company of Agate Resources, but is now owned by Centene. Their business is medical supplies and not medical care. Column D is the provider. The provider orders the supplies and should be a medical professional, not a medical supplier. Column E is the vendor who provides the supplies. As you see, the numbers in column D are all the same, as are the numbers in column E. The provider and vendor numbers, though different, are both for Lane Home Medical. These are severe and seemingly intentional Stark Law violations, which were brought to the attention of Brown, Rosenblum, and others who did nothing to remedy these criminal acts. According to the whistleblower, Lane Home Medical all by itself was involved in more than $13 million in fraud. Agate Resources owned and ran more than 30 shell companies, all of which were engaged in fraud that totaled over $2.2 billion. The following is an extremely small sampling of Agate Resources Trillium Health's criminal scams and misappropriations of U.S. taxpayers' money that Oregon public servants have turned a blind eye to and benefited from financially. An improper payment is defined by the federal government as, quote, any payment that should not have been made or was made in an incorrect amount, including overpayments and underpayments, under statutory, contractual, administrative, or other legally applicable requirements, or where documentation is missing or not available. Agate Resources Trillium Health would use a patient's name and ID number up to 15 times to bill for a single billable service, using the same CPT code and date of service for each bill. According to the whistleblower, this illegal scam was done with about 30% of billings that Trillium Health handled from Agate Resources' many shell companies. In the first example, see column F. You will see the patient labeled HO in rows 5 to 12. As column G displays, each of these 12 billings is noted as being from August 20th, 2005. Column B shows a different claim number for each of these billings. Column C shows 4 separate providers, each being associated with these 12 billings. The next example shows MC in column F associated with 8 billings on February 26, 2002, as noted in column G. All billings are associated with one provider of medical care. A little further down column F, we see MC again, this time with 15 billings on July 19, 2003, with 2 different providers. Here are some examples of Eugene physician Dr. Alexander Morley's provider number being used for multiple billings for the same patient. The whistleblower is uncertain if Dr. Morley was aware of his provider number being used in such a scan, but the whistleblower feels he was probably unaware of it. The screenshots show Dr. Morley billing for the same procedure on the same day for the same patient as both an urgent care and emergency room physician. In the first example, look at column F where we see member IDs. Column O shows the date of service. The spreadsheet separates different patients with a blank row. It is easy to see the double and triple billings for the same patient on the same day. The next example provides the member ID in column D and the date of service in column P. The first member has data entered into the Excel spreadsheet for 15 billings on September 9, 2009, with 2 different providers and 2 different vendors. Agate Resources, Trillium Health, routinely double or triple billed the Employer Health Association, Medicaid, and private insurance companies. Billing codes would be unbundled, so instead of a singular legally allowed charge for a blood panel or procedure, certain additional aspects would be teased out and billed in addition to the allowed bundle charge, so as to increase the dollar amount billed for the real or fictitious patient. Here is an example of the unbundling. Column D shows the patient initials. At the top of this column you see patient SM. There are 11 billings for patient SM for the day of November 8, 2001, as can be noted from rows 464 to 474. In column O, we see multiple CPT codes. This is where the unbundling occurs. In column J, we see that each billing is $396.50. Non-existent patient accounts were manufactured and used for falsified billings by Agate Resources shell companies. Agate Resources shell companies would submit falsified, inflated charges to Trillium Health. Trillium Health would then allow and pay these bills. Thus, the money ended up back in Agate Resources, Trillium Health's pockets, the conduit being the shell company. An example of these falsified, inflated charges is shown in this Excel spreadsheet, which documents the billing for palivizumab, RSV IgM, an antibody that is given to infants at greater risk of developing and succumbing to respiratory syncytial virus, RSV. In 2015, the recommended cost per dose was $588. In column G, highlighted in blue, we have patient initials, and column F has the member ID. Column O, highlighted in green, is a date of service, and column AC, highlighted in peach, is a charge for the service. At the top of column G, we see initials ES, who has 4 charges for the date of service, March 28, 2002, all for the same diagnosis. 2 of the charges are $1,779.35. A third one is $2,716.95, and the fourth one is $2,846.97. This is fraudulent billing of $9,124. This occurs because Trillium Health receives these known fraudulent bills from their shell companies, reimburses the charges, and thus the money ends up back in their coffers. At the top of column G is patient initials SH with 3 billings, 1 for date of service February 7, 2005, and 2 for February 8, 2005. Each date of service is billed $1,909.53, a total of $5,730 in fraudulent billings. In the next example, we have the vendor in column B, highlighted in green, and the provider in column C. Of most importance, though, is column A, which states yes, if the vendor is a business owned by the LIPA shareholders Agate Resources conglomerate. In column Q, highlighted in orange, we see patient initials BA being billed 3 times for the palivizumab antibody on November 23, 2001, as we see in column AD highlighted in peach. Each billing was for $1,380 for a total theft from U.S. taxpayers of $4,140. We see the same pattern for all the rest of the entries. Many times, one entry will be marked yes, but the rest aren't, such as we see with Caremark and BioScript Pharmacy Services. Lane Home Medical and Lane Oregon Health Plan Pharmacare are frequently noted. All these are Agate Resources Trillium Health shell companies. In column Q, at the top we see 4 charges for initials JA on March 15, 2006, for a total of $4,076 in fraudulent charges. These 4 charges are separated by 2 charges for KO on the same day. Claims for this treatment came from Agate subsidiaries, that is shell companies, which accounted for 71% of the submitted bills. They also came from Allison Harper, an optometrist in the small Oregon coastal town of Lincoln City, who would never treat RSV nor be allowed to prescribe the antibody as an optometrist. Also, Parental Therapy Associates Incorporated of Chicago, who doesn't operate in Oregon and who has had multiple federal actions against them for fraud. Lastly, BioScript Pharmacy of Florida, also not operating in Oregon. These are all Stark Law violations because the prescriber, vendor, and supplier were Agate Resources' own shell companies, such as Lane Home Medical and Lane Oregon Health Plan Pharmacare. Other huge flashing red lights include, it seems there were multiple shots of palivizumab given to the same child on the same day when it's only a single dose injection given once a month. Markedly inflated charges, all of which were above the recommended charge of $588, occurred and were inconsistent from infant to infant, even though the same quantity of palivizumab was given. The whistleblower states that all the patient records he checked in regard to the palivizumab were fake. Fake patients and falsified charges for a treatment no one even received. This was an expedient and simple way of making $12 million in profits with minimal effort and time needed by Agate Resources. Dr. Thomas Wiest was a Eugene orthopedic surgeon who was part owner and a board member of Agate Resources and their shell companies. Dr. Wiest used illegal billing practices for orthopedic procedures. Facilities were listed as the primary surgeon on billings, and Dr. Wiest would be noted as the secondary surgeon for the procedures, most of which legally allowed only a singular physician charge. Multiple charges for the same procedure on the same day were billed. Multiple charges for anesthesia given to the same patient on the same day were billed. Procedures were inappropriately coded and associated with unbundling fraud. Dr. Robert Doherty, a family practice physician, and Dr. Alexander Morley, an emergency room physician, had their provider numbers used for billing orthopedic procedures. This is strange, being that neither of them is an orthopedic surgeon. It is unknown if they were aware of how their provider numbers were being fraudulently used. In column B, we have the member ID number. In column F is the date of service. On December 15, 2003, we see the same member ID number used for 25 separate billings. There are multiple claim numbers in column A. There are multiple provider numbers in column C, along with multiple vendor numbers in column D. There are also numerous examples of illegal CPT coding. Agate Resources Trillium Health sold clients and their families' medical information and costs to employers, credit agencies, physicians, and insurance underwriters. Those sales cost employees their jobs, destroyed families, resulted in denial of home and consumer loans, cost them more dollars in charges for higher interest rates, and much more in this computer-integrated world. This illegal practice is most likely still occurring under new ownership with Centene, being that the same actors at Agate Resources, Trillium Health are still in place under Centene. These illegal practices were supposedly being used by other Oregon CCOs according to the whistleblower. This is very likely a nationwide phenomenon. The whistleblower was routinely requested to construct and run computer programs to extract patient health information and costs, and to create risk scores for Agate Resources Trillium Health clients. These were called hotspotter reports, or what is known as medical redlining. These reports were manipulated by Agate Resources Trillium Health to deny care to their clients and were also sold to interested parties. Risk scores determine the severity of a client's medical condition. For very ill clients, these risk scores would be manipulated, that is, increased, so as to withhold treatment from Trillium Health clients who would then be offered no treatment except for cheap suicide bills. What Agate Resources Trillium Health enacted was their own death panels. HIPAA-protected information was sold by Agate Resources Trillium Health to businesses in Oregon, such as Monarch and Seneca in Eugene, for profit-motivated interests. These businesses used the illegally obtained HIPAA-protected information to lay off employees whose families had high medical costs. The companies would also use this information to determine who they would hire. This same HIPAA-protected information was sold to physicians so they could cherry-pick the low-cost, healthier families and avoid the costly ones. Physicians involved in the capitated health care scheme receive a specific dollar amount per patient life per month from the CCO. This encourages rationing of healthcare dollars, being that it is tied to physician compensation. The less money spent on patients, the more in the physician's pocket. These spreadsheets are an example of the hotspotter reports sold by Agate Resources Trillium Health. Here we have an example of 2,609 employees and their dependents' medical costs for 2006. A male employee was laid off because his family's insurance costs were $509,000 in 1 year, secondary to his wife's breast cancer treatment. This was a common occurrence. Here we have a hotspotter report where 285 individuals with HIV had their information sold to private entities by Agate Resources Trillium Health. HIV positive status was sold along with name, address, and other personal information. Agate Resources Trillium Health did the same with mental health, cancer screening results, heart disease, and other risk factors and disease. Oregon prisoners, foster children, psychiatric patients, literally all patient medical information in Oregon was being sold by Agate Resources Trillium Health. Trillium bought this information directly from the Oregon Health Authority. Here we have an Agate Resources Trillium Health hotspot report on foster children in Oregon. There are 1,927 entries. The whistleblower openly questioned the legality of these practices, along with other equally illegal schemes, at an Agate Resources Trillium Health meeting, which resulted in him being demoted and openly harassed and demeaned within the company. These examples are all extremely serious HIPAA violations and are associated with severe fines and imprisonment. Everyone's medical data and costs across the United States is being sold and used to determine employment, insurability, credit scores, ability to obtain a physician, and much more. Your medical records are being used to discriminate against you. Agate Resources Trillium Health routinely denied referrals for medical care. A 4-year-old mixed-race female, KC, on the Oregon Health Plan was diagnosed with ulcerative colitis. Her physician at the time attempted to refer her to a specialist in Seattle, but this was denied by Agate Resources Trillium Health on the supposed belief that she could get better on her own, and that any necessary treatment could be taken care of in Portland, Oregon. In fact, no definitive treatment was authorized until she fell severely ill and had to be admitted to Dornbecker's Children's Hospital in Portland, Oregon. The physician's referral requested for KC was initially approved by Trillium Health's Dr. Anna Stern. Dr. Stern later resigned. It's assumed because of criminal acts such as this occurring routinely at Trillium Health. Trillium Health's medical director, Dr. John Sattenspiel, subsequently denied the request for KC to go to Seattle, or even a specialist in Oregon. A few months later, KC, whose health had been gradually worsening, deteriorated suddenly. She was rushed to Dornbecker's Pediatric Hospital, where she was hospitalized. She subsequently underwent a colectomy, which is the removal of her colon, and was placed on Remicade, which is not recommended for children her age. Neither the surgery nor the Remicade proved to be of any help, and KC died a week later. The Remicade actually likely worsened the child's medical condition. KC died a horrific death at the age of 4. Her family was devastated, but Dr. Sattenspiel saved Agate Resources Trillium Health some money. The child's life obviously didn't mean much to Dr. John Sattenspiel. If Dr. Sattenspiel had approved the referral, it might have cut into the estimated $1.9 million plus he walked away with from Agate Resources Trillium Health. Dr. Sattenspiel would never have tolerated or allowed such medical care for himself or his family. He and his family, without a doubt, would have gotten the referral for a number of different reasons. A wrongful death lawsuit was filed in state and federal courts by the deceased child's mother, but it was beaten down by Trillium Health's hired hit squad of lawyers at Stoll Reeves, along with defendant LIPA lawyers Jeffrey J. Matthews and Arden J. Olson, who were defending Dr. Sattenspiel and Terry Copeland. Mary Ann Dugan from Eugene was the mother's lawyer for the wrongful death suit. The sheer incompetence with which Miss Dugan handled the case begs the question as to whether she was simply inept or possibly working in some non-employee, financially beneficial capacity with Stoll Reeves. Miss Dugan will be discussed in more detail later in the video. Us little people never get justice in U.S. courts because we can't afford legal representation. We have no legal connections, and we are given no respect as pro se plaintiffs. Oregon state and federal judges, along with their assistants, collude with state government, corporations, and large law firms. It's all about cronyism and nepotism. There's more detail about this forthcoming. Of major importance to understanding how and why these and many other illegal scams were perpetrated by Dr. John Sattenspiel, along with many others at Agate Resources Trillium Health, relates to exorbitant salaries, bonuses, stocks, Rolls-Royce health insurance, and other benefits they enjoyed at Agate Resources and their many shell companies. All these scams were obviously run with the blessing of Oregon government, because they did absolutely nothing to stop them, even when given all details of these criminal scams by the whistleblower. These devastating scams were solely intended to keep more of the capitated healthcare dollars in Agate Resources and bureaucrats' pockets. Dr. Sattenspiel's bonuses were tied to saving money, otherwise known as denial of care. According to the whistleblower, the real power at Trillium Health behind saving money for bonuses was Chief Operating Officer Patrice Korjenik, whom the whistleblower describes as the single most evil person he'd ever encountered in his life. He states she was practicing medicine without a medical license. Ms. Korjenik dictated what medical care was allowed to be authorized by staff physicians at Trillium Health. This situation was supposedly so reprehensible that two chief medical officers for Trillium Health, Dr. Holly Jo Hodges and Dr. Anna Stern, both resigned. The Oregon Medical Board has turned a blind eye to the criminal acts of Agate Resources Trillium Health, Medical Director Dr. John Sattenspiel, owner and Medical Director Dr. Thomas Wiest, LIPA stock owner and Oregon Medical Board member Dr. Gary LeClaire, and numerous other physicians involved directly or indirectly with LIPA and Agate Resources Trillium Health. The Oregon Medical Board sells its existence to the public and politicians as being necessary to protect Oregonians from medical malfeasance. This is utter nonsense and a lie. Contrary to the rhetoric espoused by the Private Trade Association Oregon Medical Board, past and present Oregon Medical Board members, Executive Director Kathleen Haley, Executive Director Nicole Krishnaswamy, Assistant Attorney General Warren Foote, and Medical Directors Philip Parsley, Jim Peck, Joseph Thaler, and David Ferris, they have never been there to protect the public's safety. There is no evidence to prove that medical boards anywhere in the United States have ever protected the public. The Private Trade Association Oregon Medical Board is primarily in place to remove physicians they don't like for whatever reason. Some of these reasons include being a physician who is a competitor to one or more of their buddies, physicians practicing integrative medicine, physicians who won't acquiesce to the Oregon Medical Board fabricated lies and allegations about them, physicians who refuse to sign a stipulated order admitting all Oregon Medical Board charges of guilt while also giving up all legal rights, physicians who believe they have constitutional rights such as due process. The Oregon Medical Board is there primarily to protect bad to horrific physicians who are their friends, business partners, associates, family, and other board members. The following are just a handful of examples from an extensive list of Oregon Medical Board protected physicians. Dr. Seth Eisenberg, Dr. Dean Gubler, Dr. James F. Calvert, Dr. Keith White, Dr. Darrell George, Dr. Gary LeClaire. The following demonstrates the Oregon Medical Board's egregious lack of concern for public safety and well-being. Dr. James F. Calvert, who after killing at least one patient, almost killing at least one other, and the documented horrific care of many others, was allowed by the Oregon Medical Board to continue the practice of medicine without restraint in a matter of a few months after an investigation was supposedly started. Dr. Calvert misdiagnosed patients, dismissed lab results, ignored specialist evaluations, and prescribed unnecessary, inappropriate, and dangerous drug concoctions to patients. Dr. Calvert was an Oregon Medical Board, quote, medical expert, unquote, who was used specifically to lie, commit perjury, and destroy excellent medical doctors, their families, and their patients' lives. On the interim stipulated order, the date associated with Dr. Calvert's signature is X'd out, and the date associated with Oregon Medical Board Executive Director Kathleen Haley's signature simply has a 2 drawn over the 1. In each case, 2011 is changed to 2012. Both of these dates on the document are extremely suspicious for illegal tampering. As anyone should know, especially Ms. Haley, who is a lawyer, there should be a dash through the date and initials associated with this tampering. Otherwise, it is almost certain this document was produced in 2011 and subsequently altered to cover up nefarious acts. Considering the seriousness of Dr. Calvert's medical care and skills, it would not make sense for Dr. Calvert to have his license fully reinstated within 6 months. He should have been removed from the practice of medicine considering his level of incompetence. The Oregon Medical Board secured a position for Dr. James F. Calvert with the Oregon Health Authority after he was investigated by the Oregon Medical Board. Dr. Calvert was tasked with making life and death decisions for Oregon Health Plan patients in the Klamath Falls region. I have been told some extremely concerning stories about Dr. Calvert's decision-making for Oregon Health Plan patients. The Oregon Health Authority was, and most likely still is, tightly connected with Agate Resources Trillium Health, as will be addressed. Here's another example of the Oregon Medical Board's lack of concern regarding patient safety and protection from bad doctors. Dr. Gary LeClaire was a private trade association Oregon Medical Board member and a stockholder in the Agate Resources LIPA company. Dr. LeClaire knew what was occurring at Agate Resources Trillium Health and did nothing about it because that might have interfered with his stock valuations. Dr. Gary LeClaire can feign lack of knowledge of these criminal acts, but according to the Stark laws that he is in violation of, it matters not whether the provider was aware or unaware of the circumstances. Let there be no doubt that Dr. Gary LeClaire was quite aware of the criminal acts occurring. The whistleblower himself was denied surgical care for his bilateral foot fractures by his ex-employer Trillium Health, along with Moda Insurance, after he'd exposed the criminal acts of Agate Resources Trillium Health. The denial of care related to the bilateral foot surgery recommended by his orthopedic surgeon was simply retaliation for his whistleblowing. The whistleblower was terminated by Agate Resources Trillium Health for whistleblowing. Since then, he has been unable to obtain his unemployment benefits, secondary to Trillium Health and their law firm Stoll Reeves. Stoll Reeves typically has 3 and up to 5 lawyers simultaneously attacking the whistleblower, along with their paralegals, in an attempt to destroy him. The pro se whistleblower obviously represents quite the threat to warrant such a response. The whistleblower has received death threats against himself and his family from phone numbers he has traced back, with the help of the phone company, to Oregon government phones. For Oregon's general population, independent of insurance or age, the referral rate in 2015 was 65% for white patients and 30% for non-white patients. On March 12, 2013, the whistleblower was asked by Agate Resources Trillium Health's Miss Amanda Cobb to do a query on what she referred to as Black and Hispanic children. On May 8, 2013, the whistleblower received race-based risk tables put together by Amanda Cobb and Patrice Korjenik. The whistleblower has the original files containing this information. The Oregon Health Plan childhood population of Lane County is predominantly white. White Oregon Health Plan kids living with their family were granted medical authorizations and referrals only 26% of the time by Trillium Health. However, for white foster children, the referral authorization rate dropped precipitously to a mere 13%. For Native American foster children, it was 9.5%. For black foster children, it was 8%. And for Hispanic foster children, it was a pathetic 6.4%. Therefore, white foster children receive authorizations and referrals at half the rate of white Medicaid children living with their family. For Native American, black, and Hispanic foster children, it was even worse, with an overall referral and authorization rate of less than 1/4 of white non-foster Oregon Health Plan children. The take-home message from this is Oregon Health Plan children, in particular foster children, of all races have received abysmal medical care. It becomes quite clear why KC, the young child mentioned previously, was refused a referral to Seattle. First, she was on the Oregon Health Plan, and secondly, she was of mixed race. She was profiled to death by Trillium Health's economic and race-based death panels. Agate Resources Trillium Health did queries based on many variables such as sex, disabilities, sexual orientation, and much more. The whistleblower did a query of athletes on Oregon Health Plan at the University of Oregon. White University of Oregon athletes received requested referrals and authorizations 65% of the time, while for black athletes it was a paltry 25% of the time. These are blatant civil rights violations by Agate Resources Trillium Health based on race, economics, and family unit status. In 2010, the whistleblower, along with Dick Sabbath, did fraud and abuse studies for Agate Resources Trillium Health. The whistleblower has records for 3 of these studies: colonoscopies, lower back pain, and narcotic prescriptions. The whistleblower and Dick Sabbath were most interested in a study done in November 2010 regarding the apparent overprescribing of narcotics, all of which are used recreationally. What they found was that narcotics were being mailed to around 200 blind mail drops, that is, postal centers, in Lane and surrounding counties. A postal center would have multiple mailboxes leased out, and each box would have 50 to well over 100 individual fabricated patients' names associated with it. Narcotics were directly mailed to each of these fabricated patients. Trillium Health mailed out tens of thousands of pills every month. The whistleblower checked into the patient recipients for these drugs and the supposed prescribers. The patients were found to be fabricated, and the prescribers were the same self-referring, wholly owned Agate Resources facilities, Lane Oregon Health Plan Pharmacare, Employers Health Association Pharmacare, and Lane Home Medical. It seems Agate Resources Trillium Health made millions monthly from selling 600,000 plus narcotic pills a month. Mr. Sabbath closed this particular research project down suddenly for an unknown reason. This prompted the whistleblower to collect and keep records associated with this study. Federal investigators saw some of these documents July 1st, 2014. The whistleblower has given the federal court copies of prescriptions that came from these Agate Resources shell companies. These prescriptions were for an eclectic narcotic mix of aprazolam, known as Xanax, methylphenidate, known as Ritalin, Adderall, which contains 4 salts of amphetamine, oxycodone, known as Oxycontin and Percocet, hydrocodone, known as Vicodin and Norco, Tylenol with codeine, and codeine phosphate pills. Each of these drugs is used for recreational purposes in addition to medical purposes. The Oxycontin pills seem to be the most popular. Opiates on the street are typically sold for 50 cents to $1 per milligram. Therefore, the 80 milligram Oxycontin tablet goes for anywhere from $40 to $80 a tablet. The whistleblower has filed numerous court requests for access to his workstation records at Trillium Health. Stoll Reeves' attorneys seem desperate in their attempt to keep the whistleblower from them. The evidence is overwhelming that Agate Resources, Trillium Health, were engaged in selling prescription narcotics to themselves. But the whistleblower could never figure out what was done with those drugs once they were delivered to the P.O. box. Agate Resources had a pharmacy manager on payroll at the Shell pharmacies only about 50% of the time. One pharmacy manager quit and the other was fired, most likely because of illegal activities they were asked to participate in. These pharmacists' names were Teresa Lane and Shauna Wick. Amanda Cobb, who was director of Medicare at Trillium Health, would dispense drugs. She had no medical background and is not a pharmacist. She would take it upon herself to substitute a medication that had been prescribed with another drug that wasn't even from the same class of drugs. An example is substituting Benicar, an angiotensin II receptor antagonist, with lisinopril, an angiotensin converting enzyme inhibitor. She had no license to perform these tasks. The whistleblower assumes this is one huge reason why defense counsel Stoll Reeves and the federal district court have engaged in a 6-year-long battle to keep this information from being made public. Once again, because this must be prominently highlighted, patients' HIV positive status was sold to companies, credit agencies, and insurance underwriters. Agate Resources Trillium Health purchased this information for the entire state, along with lots of other patient medical information from the Oregon Health Authority. One of Agate Resources Trillium Health's many business plans focused on undocumented Hispanics who were encouraged to join Trillium Health's OHP program. Trillium's advertising was prominent where Hispanics gathered. The federal government paid $650 per month per life to Trillium Health for management of these undocumented individuals' health care in the 2015 timeframe. As long as undocumented clients came in for minor care, there were no problems. But once they needed some expensive referrals, treatments, or procedures, Trillium Health was suddenly asking for Social Security numbers, which they knew these undocumented individuals didn't have. Or Trillium Health would just outright deny the referral. Either way, Trillium Health put an end to the undocumented person's pursuit of care because of fear of their undocumented status and all it may entail. Oregon politicians act as if they care about these undocumented people, but in reality, they didn't, and they don't now. If they sincerely cared about them, Oregon politicians and government would have acted upon the information and documents given to them multiple times by the whistleblower, which clearly showed the criminal acts being perpetrated by Agate Resources Trillium Health. Suicide drugs, instead of definitive medical treatment, were frequently offered by Trillium Health to their clients. Trillium Health based their decisions upon cost analysis and manipulated risk scores. These medical decisions were made by physicians and non-physicians who had never examined, questioned, or cared for their client other than maybe looking at their medical records. So to minimize costs and retain more capitated health care money, Trillium Health would deny medical care as requested by their clients' physicians if the costs were considered too high. Instead, Trillium Health gladly offered $25 worth of suicide pills. Agate Resources Trillium Health denied and delayed referral and treatment approvals for medical issues. For example, breast or prostate cancer evaluations and treatments would be delayed until the cancer had metastasized a year or more later, and the only alternative left at that point was suicide pills. The whistleblower has experienced these same stall tactics in regard to his own medical care since being fired by Agate Resources Trillium Health for his whistleblowing. The public has posted comments on news articles that they could not get Agate Resources Trillium Health to authorize durable medical equipment such as a leg brace or compression stockings. According to the whistleblower, Agate Resources Trillium Health would even deny pain pills to those dying of cancer, just so they could keep money allocated for patient care in their pockets. At the same time, Agate Resources Trillium Health were seemingly selling and or distributing narcotics. Trillium Health was legally required to have a primary care physician for every Oregon health plan and Affordable Care Act life they managed. Trillium Health received $650 per month per life from the federal government, that is, the taxpayers, to manage these lives. Unfortunately, Trillium Health didn't have enough physicians to accomplish this requirement. The whistleblower states there were 28,000 lives under Trillium's management without a primary care physician, in the 2014 time period, all of whom had little to no access to health care as a result. The whistleblower states that the reported 9,000 clients without a primary care physician is a low-ball fabrication by Trillium Health for the media. How did Trillium Health cover up this problem? Very easily. They kept physicians' names on their provider list that had severed ties with Trillium Health. As a result of hotspotter reports generated by the whistleblower and then sold to physicians by Trillium Health, many patients who were considered high cost and unprofitable were dropped from physician practices or never accepted into a physician practice for care. Lane County politicians, working in collusion with Agate Resources Trillium Health, took federal money from low-income health and housing grants and used it to establish and staff 2 clinics with 4 physicians total to help care for Trillium Health's 28,000 client patients that didn't have a PCP. Trillium supposedly did not contribute financially to these projects, though they stated they were going to contribute $500,000. In 1999, when Trillium Health became involved in LIPA, Lane County Independent Physician Association, and Terry Copeland became owner and president of LIPA, each physician in LIPA was expected to contribute $6,000 and in return would be issued 1 share of stock. The whistleblower states few physicians ever paid the $6,000, but they still received stock shares. On September 1, 2015, Agate Resources Trillium Health was sold to Centene, a massive national player in the Affordable Care Act arena, for $109 million, according to media reports, though the whistleblower states it was only $80 million. Top management and physician players within Agate Resources, Trillium Health, and LIPA, in particular those on the board, along with some government figures, had prior knowledge that Agate Resources, Trillium Health, and their associated shell companies were going to be sold to Centene. According to news reports, just prior to Centene purchasing Agate Resources Trillium Health, a one-time $36 million dividend was approved by Agate Resources and the LIPA board to be distributed to shareholders. As a result, their stocks exploded in value. The whistleblower disagrees with the $32 million dividend figure given by the press and states the dividend was well over $131 million and likely up to $192 million. In preparation for this stock dividend, the Agate Resources Trillium Health insiders began encouraging unknowing shareholder physicians and employees within LIPA to sell their stocks to them for $300 per share. Agate Resources' Terry Copeland and crew were pumping out thousands of shares of stock on a monthly basis that were available to only a handful of people. In 2011, there were 68,775 outstanding shares. At $1,900 a share, their value would be $130,672,500. As of August 31, 2013, prior to the whistleblower being fired, there were 100,911 outstanding A shares, according to the whistleblower. At $1,900 per share, their value would be $191,730,900. Trillium Health's stock and bonus payout amounts do not match or add up. This brings up the significant issues of Agate Resources, Trillium Health committing fraud. Notice that those with the most stocks were either members of the board or were corporate officers. No doubt insider knowledge was at play here. Looks like a multitude of Security and Exchange Commission violations. This Excel spreadsheet lists the owners of LIPA stock. Columns C/D are non-MD holders of stock. Columns I/J are physician holders of stock with their medical specialty next to them. Column M shows the number of stocks owned as of December 31st, 2010. Column N shows total shares owned by the individual as of August 31st, 2013. Highlighted in yellow are stockholders with a large number of shares and those who worked administratively within the Agate Resources empire. Column L denotes whether the individual is on the LIPA board. If they have a 1 in their row, they are a board member. Individuals of note include former Eugene Mayor Jim Torrey, Dr. Arya Kehan, Dr. Richard Barnhart, Dr. Leo Citronbaum, Dr. Richard Finkelstein, Dr. Todd Hayes, Dr. Richard Hoffman, Dr. Mark Myers, Dr. Christopher Miller, Dr. Stanley Ruff, Dr. Thomas Wiest, Dr. John York, Rhonda Busick, Amanda Cobb, David Cole, Shannon Conley, Terry Copeland, Dr. John Sattenspiel, Jim Korfhage, Scott Curry, Stephen Wendell, Jordan Popp, and Patrice Korjenik. By the time Centene purchased Agate Resources, Trillium Health, and their shell companies, they already had an extremely tarnished reputation for many years. To date, Centene has gotten away with just a hand slap for numerous criminal acts, seemingly because of state and federal government and judicial assistance and a board of directors made up of people like former Senator Dick Gephardt. All those involved with Centene have seemingly traded in their moral grounding and compass for a buck. Centene CEO and Chairman Michael Neidorff earned $19.3 million in 2014, in addition to receiving $13.9 million in Centene stock that same year. And from the article, quote, "Senior management at major health insurance corporations are living large at the expense of others' misfortune. A recent analysis of health insurance executive salaries show that the industry's top 70 executives made $2 billion in 2015. CEO salaries averaged $20 million per year. Centene HealthNet CEO Michael F. Neidorff made the most of all, topping out at $22 million last year, that is 2017. That same year, median household income was $55,775 per year, while the insurance executives made $100,000 a day," unquote. Over the past 30 years, Centene has grown from a single health plan in Wisconsin to become a $10 billion Fortune 500 company trading on the New York Stock Exchange. Centene's health plans serve 2.9 million clients in California, Washington, Florida, Illinois, Massachusetts, Ohio, and Texas as of 2015. Your health is a commodity traded on the stock market. Your ill health is a financial liability. We all know what that means. So with this plethora of publicly available knowledge regarding Centene's criminal past readily available to anyone who made even a cursory internet inquiry, why would the state of Oregon allow the purchase of Agate Resources, Trillium Health by Centene? In Oregon, the purchase of Agate Resources, Trillium Health by Centene is the work of disgraced Governor John Kitzhaber, Secretary of State and now Governor Kate Brown, Attorney General Ellen Rosenblum, the Oregon Health Authority's disgraced Director Lynn Saxton, Oregon Insurance Commissioner Lauren Cowley Robinson, who was 33 years old at the time and who now works at the Oregon Health Authority, their dishonest subordinates and superiors, corrupt courts, criminals at Agate Resources, Trillium Health, and legal bully Stoll Reeves Law Firm, headquartered in Portland, who act as legal muscle for both corporate and Oregon government entities. Ms. Rhonda Busick was a lobbyist for Agate Resources Lane Individual Physician Association, known as LIPA, from 1996 to 2011. At the time of the sale of Agate Resources Trillium Health to Centene, Ms. Busick owned enough shares of LIPA stock, which she was supposed to have divested herself of after leaving the company in 2011, to net her at least $1 million. From 2013 to 2019, Ms. Busick worked at the Oregon Health Authority. When the Oregon Health Authority was audited by the Oregon Secretary of State's office in 2017, the Oregon Health Authority refused to cooperate. Hundreds of millions of Oregon Health Plan dollars were unaccounted for by the Oregon Health Authority for years. Ms. Busick's exact role in the Oregon Health Authority's refusal to cooperate with Secretary Richardson's audit is unknown, but the Oregon Health Authority pushed back extremely hard, refusing to hand over documents requested by the auditors. Now, I was under the impression that bureaucrats were our public servants. My bad. It seems they are the public's overlords. Governor Kate Brown and Attorney General Ellen Rosenblum did absolutely nothing to stop the Oregon Health Authority's criminal behaviors. Must be because they care so much about the public and the taxpayer. After the Oregon Health Authority Director Bruce Goldberg resigned in disgrace in March 2014, Ms. Lynn Saxton was appointed the Director of the Oregon Health Authority by Governor John Kitzhaber. She was confirmed January 12, 2015. Ms. Saxton was contacted in 2015 by the whistleblower about Agate Resources' Trillium Health criminal acts. She was given documents to substantiate these allegations, but once again, nothing was done to remedy the problem. Ms. Lynn Saxton resigned, that is, she was fired, in August 2017 after a plan she had concocted to plant false stories about family care, a CCO in Oregon she disliked and was feuding with, leaked out. At this point, she had become an embarrassment and liability to her superiors and was terminated. Ms. Saxton is the bureaucrat primarily responsible for the massive pushback against Secretary Richardson's audit of the Oregon Health Authority. Many other public servants, such as Governor Brown or Attorney General Rosenblum, were also intimately involved. Ms. Callie Robinson, at 31 years of age, was appointed Oregon Insurance Commissioner July 15, 2013, by then-Director Patrick Allen of the Department of Consumer and Business Services. The Insurance Commissioner serves at the pleasure of the Director. This appointment came with the blessing of then-Governor John Kitzhaber. Lauren Callie Robinson served as Oregon Insurance Commissioner until September 2017. She then transitioned to the role of Chief Financial Officer for the Oregon Health Authority after her boss, Patrick Allen, was named Director of the Oregon Health Authority by Governor Kate Brown to replace disgraced Lynn Saxton. It amazes me that anyone that is 31 years old, with no significant, if any, experience in this role, nor medical knowledge, was put into a position of such extreme importance. This brings up a lot of concerns and questions. Maybe the following quote is one reason Ms. Callie Robinson received the appointment. Quote, "Earlier, the Eugene Register Guard reported that the Oregon Insurance Division had blacked out the identities of Agate's 217 individual owners and the payouts they would receive under the sale." Unquote. These stock payouts were in the tens of millions and likely closer to 200 million, and came from money that was illegally procured and intended for the poor. Ms. Lauren Callie Robinson oversaw this massive financial deal that involved real human lives and their health, as did her boss Patrick Allen, Governor John Kitzhaber, Secretary of State Kate Brown, Attorney General Ellen Rosenblum, and many other government officials. Here is another possible reason Ms. Callie Robinson was brought in to help facilitate the sale of Agate Resources' Trillium Health to Centene for political and corporate players. The following are selected statements from the document, quote, "In the matter of the proposed plan of acquisition of control of Trillium Community Health Plan, Incorporated, Eugene, Oregon, by Centene Corporation, St. Louis, Missouri. Signed off by Oregon Insurance Commissioner Lauren Callie on June 25, 2015, unquote. Quote, "Centene subsidiaries offer healthcare services in several states, including California, Washington, Florida, Illinois, Massachusetts, Ohio, Oregon, and Texas. Centene is a Delaware corporation. Its common stock is publicly traded on the New York Stock Exchange under the ticker symbol CNC, unquote. Therefore, your life and its associated healthcare needs are commodity, used to make a profit at any cost for shareholders, even if it means Centene withholding healthcare from their clients. Quote, the acquisition by Centene will enhance, not jeopardize, the financial stability of the domestic insurer, unquote. Quote, there is nothing to suggest that the competence, experience, and integrity of those persons who will control the operations of the domestic insurer, Trillium Health, will not be in the interest of the policyholders of the domestic insurer and of the public so as not to permit the proposed acquisition or its consummation, unquote. The public's interest was never in Agate Resources' Trillium Health's interest before they were purchased by Centene. Similarly, it seems the public's interest has never been a concern for Centene prior to the purchase. Ms. Callie Robinson's Oregon Insurance Commission document is pure rubbish. She knew these companies were filthy, and if not, she was incompetent in her position of authority. Lauren Callie Robinson had received information from a number of individuals who recommended against the acquisition by Centene, one of them being the whistleblower, who was willing to supply all information he had regarding Agate Resources, Trillium Health's malfeasance. Instead, Ms. Callie Robinson was willing to not only compromise herself, but also the citizens of this state and the U.S. taxpayer. As noted earlier, the whistleblower for over a decade alerted a number of elected public servants about Agate Resources, Trillium Health's numerous criminal acts, along with providing documentation to support his allegations. Agate Resources, Trillium Health's violations were theft from the American taxpayer. These violations resulted in adverse medical outcomes for their clients, sometimes even death. Elected and unelected public servants who took an oath to uphold the Constitution and laws and to protect the public did nothing even when presented with irrefutable evidence on a silver platter of Agate Resources, Trillium Health's criminal acts. Secretary of State Dennis Richardson was elected in November 2016. The whistleblower finally found someone who listened to his allegations and looked at his evidence. Unbeknownst to the whistleblower, an audit to look into his concerns was begun by Secretary Dennis Richardson's Audit Division, along with Richardson's own concern of hundreds of millions of dollars that the Oregon Health Authority could not account for. As Secretary Richardson's audit notes, $60 million in bonuses went to Centene and $70 million went into a reserve fund, which under Oregon law is the company's money. 100% of this $130 million came from Medicaid and Medicare money looted from the system through various mechanisms noted earlier. Here are some prime excerpts from that audit. Quote, Oregon's $9.3 billion per year Medicaid program, unquote. Quote, approximately 1 million Oregonians are enrolled in the state's Medicaid program, the Oregon Health Plan. This represents approximately 27% of the state's population, unquote. Quote, the Oregon Health Authority has gaps in procedures for preventing certain improper payments, insufficient management of the agency's processes for identifying and resolving payment and eligibility issues, prioritization of staffing resources, and efforts to address technology issues put taxpayer dollars at risk, unquote. Quote, the Oregon Health Authority lacks well-defined, consistent, and agency-wide processes to detect certain improper payments, especially related to coordinated care organizations. We identified approximately 31,300 questionable payments based on our review of 15 months of data, unquote. The whistleblower states this number is quite low and is actually in the hundreds of thousands of questionable payments. Quote, Oregon Health Authority reported completing the action plan to determine eligibility for the remaining backlog of 115,200 Medicaid recipients. Approximately 47,600, or 41%, were deemed ineligible as a result, although this figure may decrease slightly through the end of November. Failure to address this issue in a timely fashion resulted in approximately $88 million in avoidable expenditures, unquote. Quote, serving as a single state Medicaid agency, Oregon Health Authority is responsible for all aspects of Oregon's Medicaid program, including preventing, detecting, and recovering improper payments, unquote. Quote, our audit work was limited by prior agency management. At times we were prevented direct access to staff, had our interviews with staff monitored, had our information requests delayed, and were occasionally provided with incomplete and or inaccurate information, unquote. Quote, some employees informed us that their manager had directed them to not respond directly to auditor follow-up questions and to send their responses through managers, unquote. Quote, in addition, Oregon Health Authority management monitored our contacts with agency staff. In one example, an employee was flanked by 2 managers and Oregon Health Authority's chief auditor for an audit interview. In another example, a total of 6 agency staff, including Oregon Health Authority's prior chief financial officer, chief operations officer at the time, accompanied one auditor around during a tour of Oregon Health Authority's eligibility processing center, unquote. Quote, the Oregon Health Authority delayed answering requests and at times provided incomplete or erroneous information, unquote. Quote, the lack of strong improper payment detection procedures poses a significant risk to Oregon's Medicaid program, unquote. Quote, Oregon Health Authority program integrity efforts have gaps and weaknesses, with system controls lacking in certain areas. CCOs, who are key stakeholders in detecting improper payments, also generally appear to lack effective and proactive improper payment detection and recovery processes." Unquote. Quote, "The agency was unable to provide a comprehensive system edit and audit inventory." Unquote. Quote, "Some CCOs appear to perform only limited activities to detect improper payments." Unquote. Quote, "Oregon's Medicaid program has been identified as one of the most complex programs in the nation due to large numbers of CCOs relative to the state's population." Unquote. Quote, "The Oregon Health Authority has never sanctioned a CCO despite documented compliance issues and authority under federal regulations and contractual terms." Unquote. Quote, "4 CCOs had findings that may contribute to a higher risk of improper Medicaid payments." Unquote. Quote, "Without clearly defined rules and contracts, it is difficult for Oregon Health Authority to hold providers and CCOs accountable." Unquote. Quote, "The Oregon Health Authority is likely not detecting many improper payments that could be recovered." Unquote. Quote, "Unlike Oregon, those states were more transparent." Unquote. Mr. Terry Copeland is the individual who created the criminal enterprises known as Agate Resources and Trillium Health, along with a myriad of shell companies, offshore accounts, and illegal schemes to defraud their own clients, Medicaid, Medicare, private insurance companies, and the United States public and taxpayer. To date, through his political donations and connections, Terry Copeland has been able to evade justice. He currently works for Centene Corporation and is most likely continuing the same illegal and criminal activities he was involved with prior to his Agate Resources Trillium Health empire being sold to Centene. Centene itself is no stranger to defrauding the public. Centene has found themselves in court many times around the United States for similar criminal acts. In 2013, Mr. Terry Copeland earned $366,530. In 2014, Mr. Copeland earned $492,324, along with a compensation package that included top-notch health care benefits, a $96,230 bonus, and stock awards of $46,000. I assume his current compensation at Centene must be higher than what he earned 6 years ago. Just prior to the sale of Agate Resources' empire to Centene, it was reported in the press that Mr. Copeland made $6 million from his Agate Resources and LIPA-related stock. The whistleblower feels Mr. Terry Copeland made at least $15 million based upon the number of stocks outstanding in 2015. The whistleblower alleges that Terry Copeland served on the SAFE Board, the State Accident Insurance Fund, after supposedly bribing now disgraced former Governor John Kitzhaber. SAFE is a state-run workman's compensation insurance fund. The whistleblower asserts that Oregon has gone to great lengths to scrub Terry Copeland's presence from state websites. I attest to the fact that I could find nothing on the internet showing Terry Copeland having been appointed to the SAFE Board. Patrice Korjenik was the chief operating officer at Trillium Health. Ms. Korjenik ran the patient profiling and risk assessment schemes, the denial of medical care schemes, and the massive buildup of reserves for Agate Resources. She owned a significant amount of Agate Resources stock and made well over the $1 million reported in the Eugene Register-Guard upon its sale. Dr. Thomas Wiest was an orthopedic surgeon in Eugene, Oregon, and part owner of Agate Resources. He was also part owner and president of Trillium Health, Slocum Orthopedic Clinic, and other Agate Resources shell companies such as LIPA, Lane County Independent Physician Association. He became the medical director of Trillium Health prior to the Centene sale and still currently holds that extremely lucrative position. He made at least $3 million from the sale of his stock and more likely closer to $10 million. Mr. David Cole was the chief financial officer at Trillium Health. He was quite aware of the illegal financial schemes occurring at Agate Resources, Trillium Health, and their shell companies. He profited greatly from them in regard to salary, benefit, and stocks. He made $4.2 million from the sale of his stock, according to the Eugene Register-Guard, but the whistleblower states it was much more. Dr. John Sattenspiel was the medical director for Trillium Health until August 2014. He, quote, resigned, unquote, after Agate Resources, Trillium Health, discovered he'd spoken to a fly-tying group at the whistleblower's house regarding aspects of Agate Resources' illegal workings. 6 individuals were present when Dr. Sattenspiel exposed this criminal information, as noted in their notarized witness declarations. Dr. Sattenspiel swore that he hadn't divulged any privileged information about the company, but he did end up signing a non-disclosure agreement with Trillium Health and was paid $1.9 million upon his resignation, at least $550,000 coming from his stock, according to the whistleblower. Ms. Shannon Conley reportedly made at least $2.1 million from her Agate Resources LIPA-affiliated stocks. Somehow Ms. Conley has become a vice president at Trillium Health Centene with reportedly only a high school degree. Now, what are the odds of that? According to the whistleblower, Shannon Conley helped create false medical records for Agate Resources, Trillium Health, along with Judy Byrne and Tina Potter. Think that might have helped Ms. Conley slide into that vice president position for Centene? Ms. Amanda Cobb Franson, with a college degree in music and creative writing, was given the title of Director of Medicare by Agate Resources, Trillium Health, which she still holds today with Centene. She also seemingly benefited greatly from owning stock. Ms. Cobb ran the mail-order pharmacy where she would substitute cheaper meds in place of the ones prescribed by the plaintiff's physician. Most likely she was involved with the narcotics scheme Agate Resources Trillium Health was running. Ms. Cobb is not a pharmacist. Ms. Cobb would literally bottle the prescriptions herself with the help of underlings, according to the whistleblower. Mr. Jim Torrey is a former Eugene, Oregon mayor who was a shareholder and board member of Agate Resources LIPA. He made at least $2.5 million upon the sale of his stock in 2015. It would be extremely interesting to know as to when Mr. Torrey accumulated his stock, when he became a LIPA board member, and if any of his votes as mayor favored Agate Resources Trillium Health. Mr. Torrey is another individual who says he is for the children, but his actions don't back that up. Miss Debbie Farr has worked for Trillium for the past 8 years and prior worked at Oregon state government. She most likely had Trillium stock that she benefited greatly from prior to the Centene sale. Her husband, Pat Farr, is a Lane County commissioner. According to the whistleblower, Mr. Farr worked to steer grant and tax money to bail out Trillium after the whistleblower exposed Agate Resources, Trillium Health's non-compliance with Medicaid Affordable Care Act regulations mandating that every patient have a primary care doctor. Both Farrs were friends of disgraced Lynn Saxton and her husband, Ron Saxton. Jordan Papp is CEO of the Papp Group in Eugene, Oregon. The Papp Group Incorporated operates as a holding company. The company, through its subsidiaries, provides capital equipment rentals, repair and part replacement services to construction, forestry, agriculture, warehousing, business aviation, material handling, and trucking industries. Mr. Papp was a shareholder of LIPA and on the Agate Board of Directors. Mr. Papp wrote a letter to Lauren Cowley, the Oregon Insurance Commissioner, encouraging her and the state to allow the sale of Agate Resources Trillium Health to Centene. Mr. Papp's only reason for being so interested in the sale most likely boils down to the LIPA stock he owned. As a board member, he should have had direct knowledge of Agate Resources Trillium Health and their illegal schemes. Jordan Papp received at least $1.4 million from the sale of the LIPA stock. Ms. Heather Bush is a Lane County commissioner who was alerted by the whistleblower to Agate Resources Trillium Health's criminal activities. Ms. Bush chose to ignore them. Ironically, she promotes herself as a politician of the little people. Stoll Reeves Law Firm, headquartered in Portland, Oregon, has a national reach. According to the whistleblower, they are the legal muscle that protects Oregon government and companies such as Agate Resources Trillium Health. They have numerous lawyers spread out primarily across the western United States. Stoll Reeves lawyers have been assigned to attack and destroy the whistleblower, who is pro se, meaning that he is representing himself in court, because of his knowledge and exposure of state and corporate criminal acts. Stoll Reeves has spent a tremendous amount of time and money since 2013 to prevent the whistleblower from receiving his unemployment benefits, workman's compensation, and medical injury claims from Agate Resources, Trillium Health. Some of the Stoll-Reeves lawyers involved in attempting to destroy the whistleblower have included Carolyn D. Walker, Stephen Galloway, Riley D. Keating, Rachel Lee, Ryan Gibson, Brianna Brigham, Bradley F. Tellum, along with a half-dozen paralegals. Stoll-Reeves lawyers are assigned 3 and up to 5 at a time to battle a single pro se plaintiff. What is particularly disturbing is that Carolyn D. Walker, a heavy hitter in the Black Lives Matter organization and movement, is involved with protecting government and corporations that are destructive to black lives in Oregon. Ms. Walker represents entities that have denied all races, including black adults and children, access to basic medical care, which has resulted in innumerable deaths and injury. Ms. Walker seems more interested in protecting the assets of the extremely privileged and wealthy, while hypocritically acting as if she is a warrior for the downtrodden. She certainly has no problems destroying our Native American whistleblower, who is fighting for the underprivileged of all races and the hardworking American taxpayer who makes nowhere near the incredibly unaffordable per-hour rate Ms. Walker charges for her services. As you see, Ms. Walker has criminal friends in high places. On January 20th, 2014, the whistleblower was awarded unemployment benefits by Oregon Administrative Law Judge K. Monroe. Judge Monroe found the whistleblower had been dismissed from his job at Trillium Health without cause. Immediately after Judge Monroe's decision, a meeting was arranged with Governor John Kitzhaber by Agate Resources Trillium Health's CEO and owner Terry Copeland, Medical Director and owner Dr. Thomas Wiest, and Chief Operating Officer Patrice Korjenik. Others involved with this arranged meeting were Governor Kitzhaber's #1 campaign official Kevin Neely, #2 campaign person Kristen Leonard, Kevin Neely's wife and an Agate Resources Trillium Health lobbyist, and Kitzhaber's girlfriend Sylvia Hayes, a lobbyist for Agate Resources Trillium Health. According to the whistleblower, the Agate Resources Trillium Health Group paid Kitzhaber $40,000 to form a 2-person sham judicial team composed of #1, former state senator Anthony Tony Corcoran, who was a friend of Agate Resources and Trillium Health. Mr. Corcoran's wife, Jeannie Merrick, worked as a nurse practitioner at Oak Street Medical in Eugene, a Trillium Health subcontractor. 99% of Oak Street's medical business was dependent upon Trillium Health. And #2, Governor Kitzhaber's aide, Susan Rossiter, a Portland lawyer. Governor Kitzhaber chose these 2 individuals to re-decide Administrative Law Judge K. Monroe's decision. This is unheard of and absolutely illegal. Judge Monroe's decision regarding the whistleblower was overturned by the 2-person sham judicial team of Anthony Tony Corcoran and Susan Rossiter, whose final decision was written up by Stoll-Reeves' attorney and partner, Carolyn D. Walker. After Governor Kitzhaber's illegal 2-person sham judicial panel overturned Judge Monroe's decision regarding the whistleblower's unemployment, workman's compensation, and medical benefits, the whistleblower filed a complaint June 4th, 2015, with the Federal District Court in Eugene. The lawyer involved with this initial filing was soon replaced by Mary Ann Dugan at the request of 3 other lawyers who had become involved in the whistleblowing aspect of the case involving federal law violations and their associated fines. Article 3 Judge Ann Aiken presided over the case, but she passed it to Magistrate Judge Jolie Russo and Judge Michael McShane over plaintiff whistleblowers' objections. Judge Jolie Russo was deeply involved with the Oregon Department of Justice attorneys that had covered up wrongdoing by Trillium Health, Lynn Saxton, and Oregon state agencies. Under Federal Rule of Civil Procedure, FPRC 73, that was unlawful. The whistleblower was threatened and retaliated against by Judge Aiken for his opposition to Judge Russo being involved in the case, and for asserting his legal rights regarding FRCP 73. The Oregon Eugene District Court went so far as to block Rule 72C in whistleblower's appeal to the Ninth Circuit. The whistleblower sent a mandamus to Judge Sidney Thomas of the Ninth Circuit. Judge Thomas held on to the mandamus and then dismissed it without ever telling the whistleblower, thus depriving him of his right to appeal to the U.S. Supreme Court. The degree of corruption and collusion by these rogue judges is unbelievable. Discovery for the case was postponed by Stoll Reeves in April 2017 until October 2017, as is noted in available emails. Marianne Dugan made it clear to Stoll Reeves at the end of April that she would be out of state for almost 3 months, beginning early June 2017. Once Miss Dugan left Oregon, Stoll Reeves began sending documents, letters, emails, and made phone calls to Dugan's office while her practice was shut down. Of note, Miss Dugan ran the office by herself. They knew Dugan would not be responding to these legal materials until she got back. Stoll Reeves also never copied whistleblower, as was, quote, commanded, unquote, by the federal district court. Judicial political activist, Magistrate Judge Michael McShane dismissed the case June 28, 2017, while plaintiff whistleblower's lawyer was unreachable and prior to any discovery, depositions, etc. in the case. It seems Judge Michael McShane's activism does not include upholding the Constitution or the rule of law. This unlawful and cold-blooded decision by Judge Michael McShane was appealed once Ms. Dugan returned back to Oregon. The whistleblower plaintiff alleges that Magistrate Judge Russo of the Eugene Federal District Court had ex parte contact with Stoll Reeves' lawyers Riley Keating and Stephen Galloway and communicated to them on August 23, 2017, her predetermined decision on a motion to compel that was supposed to be deliberated 8 days later on August 31, 2017. In addition, Judge Jolie Russo permitted the theft and destruction of plaintiff's property by Stoll Reeves. After Marianne Dugan returned to Oregon, she was late filing legal documents for the whistleblower's case, as well as withholding whistleblower's physical disabilities from the court. At that juncture, the whistleblower decided to proceed pro se, that is, represent himself in court. The whistleblower could no longer trust Marianne Dugan's competence, integrity, honesty, and allegiances based upon both his case and the wrongful death case she represented for the family of the child with ulcerative colitis. Subsequently, Ms. Dugan, after having been fired by the whistleblower plaintiff on September 7, 2017, removed the whistleblower's legal records Sunday, September 11, 2017, from Alan Lehman's and Drew Johnson's locked law office. Lyman and Johnson had pushed whistleblower to fire his first lawyer and to hire Ms. Dugan to work with him on his federal district court case. Ms. Dugan delivered whistleblower's records via email Dropbox to Stoll Reeves on September 11 and 12, 2017, in return for unknown benefits. The whistleblower property that Marianne Dugan removed and gave to Stoll Reeves consisted of dozens of original uncopied documents that plaintiff had provided to his legal team. Federal District Court Judge Ann Aiken and her magistrate judges ignored all of the whistleblower plaintiff's written complaints about these and other illegal irregularities like the FRCP 73 violation. Judge Ann Aiken threatened plaintiff with retaliation if he continued objecting to the sham that was unfolding at the Eugene Federal District Court. November 20, 2017, Magistrate Judge Jolie Russo dismissed plaintiff's appeal to rehear the whistleblower's case Judge McShane dismissed. Judge McShane had excluded plaintiff and his counsel from deliberations, discovery, depositions, and more prior to his dismissal. These federal district court judges certainly seemed determined to assist Agate Resources, Trillium Health, and others in their war against the whistleblower so as to keep criminal acts hidden. Judge Aiken seems to have assisted Governor John Kitzhaber and Agate Resources Trillium Health in eluding justice. Judge Ann Aiken sealed all records related to the investigation of Oregon Governor John Kitzhaber, an investigation that the whistleblower had been part of, at around the same time the whistleblower's federal complaint was dismissed. Certainly seems there was substantial conflict of interest with Judge Ann Aiken's court's participation in the whistleblower's federal case, which should have been moved out of Oregon and probably even to a different circuit court, considering the hostile and criminal government and legal environment whistleblower was attempting to work within. The whistleblower, in response to his federal complaint's dismissal by Judge Aiken's Eugene Federal District Court, filed a brief with the Ninth Circuit Court of Appeals August 2, 2017. The Ninth Circuit is considered the most corrupt and inept circuit in the United States, with an 80% reversal rate of their cases heard by the Supreme Court of the United States. The whistleblower was hospitalized in November 2019 with severe cardiac arrhythmias, the result of severe cervical spine disease. The whistleblower required surgery and extended rehabilitation. During this time, Stoll-Reeves sent a steady stream of documents to the Federal Appeals Court, 27 filings totaling more than 700 pages. Stoll-Reeves was fully aware of the whistleblower's medical circumstances and that he was pro se. In addition, the whistleblower had undergone right retinal detachment surgery in 2013, a result of his work with Trillium, which still interfered with his ability to read and see. The whistleblower is currently still working within the appeals court. Throughout the course of the whistleblower's legal proceedings, Stoll-Reeves has altered, concealed, and destroyed documents related to the case. Stoll-Reeves has claimed they are unable to access files on DVDs produced by the whistleblower. Ignoring HIPAA law, Stoll-Reeves illegally obtained the whistleblower's medical records from MOTA, his health and dental insurance company. MOTA has handled the whistleblower's medical claims for years, and were fully aware of the whistleblower not wanting release of any of his medical information to any party without his blessing. Additionally, the whistleblower had specifically asked the Federal Appeals Court to seal his health records and to keep them from Stoll-Reeves. First, they were none of Stoll-Reeves' damn business. Second, they had nothing specific to do with the case. And third, they were HIPAA protected. The whistleblower released these health records solely to the federal courts to demonstrate why the whistleblower needed an extension of time for his appeals case. Here are some excerpts from the whistleblower's federal appeal brief. Quote, "The very first thing plaintiff did after finding that fraud at Trillium Health was telephone Secretary of State Kate Brown on February 10, 2012 and report it. Brown had plaintiff report that to her audit division on February 15, 2012. Oregon buried knowledge of that fraud, covered it up. State officials used that as a means to pry campaign donations from state contractors." Unquote. Quote, "What this court has is a series of unlawful actions by both Oregon, the District Court, and Defense Counsel, sometimes in collusion with one another, to deny plaintiff his right to due process and a fair hearing. On recorded telephone calls, this court has a bully attorney talking of filing specific whistleblower retaliation complaints. That turns out to be a bald-faced lie. Oregon did not file those complaints, in spite of their claims to have done so. OSHA, Occupational Safety and Health Administration, who met with Stoll-Reeves attorneys and state officials, lied about having conducted an investigation and instead can be shown to have engaged in attempts to suppress an investigation of racketeering by Oregon and its contractor, Trillium." Unquote. The whistleblower gave BOLI, the Bureau of Labor and Industry, all evidence necessary to document illegal acts on the part of Agate Resources Trillium Health and to file whistleblower retaliation paperwork for the whistleblower. Commissioner of BOLI at that time was Brad Avakian. The whistleblower himself saw the whistleblower retaliation paperwork filed by a Mr. Wolf who worked for BOLI, but somehow it later disappeared, as did Mr. Wolf. BOLI, that is Brad Avakian, then attempted to gaslight the whistleblower by saying there had never been a conversation between BOLI and the whistleblower. Unfortunately for BOLI, the whistleblower had recorded the conversation. Of note, Donna Brown, who at one time worked for Stoll-Reeves, has been special aide to the Oregon Labor Commissioner since 2009. Quote, "In the just concluded federal case, Shorb et al. V. Lane Individual Practice Association et al., filed November 24, 2014, both Agate and the state of Oregon argue that Agate is a state agency, and both OHP and Agate enjoy 11th Amendment protections against federal suits. A case I am very familiar with since Agate conducted risk assessments on KC, the child involved, and overturned medical authorization for treatment, resulting in this little girl's death." Unquote. This is the wrongful death case involving the 4-year-old who died of ulcerative colitis and was denied referral to a specialist in Seattle by Trillium Health and their medical director, Dr. John Sattenspiel. So here we have the private, for-profit company Agate Resources and the state of Oregon arguing that a private, for-profit business has fictional sovereign to absolute immunity status. It's make it up as you go in Oregon government courts. Quote, Agate senior management determined that medical treatment was too costly, and so they offered medically supervised suicide or nothing at all, unquote. It can be difficult to determine the specifics of many contributions to politicians because they are hidden by faceless political action committees, with typically a touchy-feely name associated with them, or single names you'd never recognize, let alone their personal political connections. This conspiracy goes very deep and broad. Here are just a few small examples of what we do know. Kate Brown in 2008, 2012, 2016, and 2018 received $65,000 from Centene, $10,737 from Stoll Reeves, and $16,000 from Moda Insurance. Kate Brown was given the exact same amount from each of these companies for each year noted. Interestingly, Secretary of State Kate Brown and others were receiving big campaign contributions from Centene before they were even an Affordable Care Act player in Oregon. Agate Resources, Trillium Health, wasn't sold until 2015 to Centene, so the rails were being greased for some time prior, as early as 2008, so that the sale would go through smoothly at a later date. Another example of the rails being greased is the inexperienced Lauren Callie Robinson being placed in the position of Oregon Insurance Commissioner at the age of 31 in 2013. Lauren Callie Robinson obviously was willing to be part of a criminal racketeering conspiracy to move ahead professionally because she had no qualifications to have held such a position at 31 years of age. John Kitzhaber in 2010 and 2014 received $8,500 from Stoll Reeves each of those years. Ron White in 2010 received $8,500 from Centene. In 2016, he received $8,500 from Centene and $4,500 from Stoll Reeves. Oregon courts are being packed with lawyers from law firms who donate to politicians. And reading directly from the article, Stacked Courts and Campaign Contributions, quote, last week, Governor Brown announced that she is appointing attorney Jackie Kamens to the appeals court bench, despite Kamens having no experience as a lower court judge. What Governor Brown didn't mention is that the law firm Kamens works for, Markowitz Herbold, just happens to be a huge donor to Kate Brown's political campaigns over the years. Between the law firm as an entity and employees of the firm, they've contributed $26,770 to Brown over the years. Even more disturbing, they've donated $3,500 to Attorney General Ellen Rosenblum as a company and another $1,274 as individuals. Now Kamens, one of their attorneys, will be judging cases that Rosenblum's office is a party to, as every criminal appeal is represented by Rosenblum's state attorney general's office. This creates a significant conflict of interest. In total, Markowitz Herbold, as a company entity, has contributed $61,689 to political causes. Employees of the firm have contributed a total of $57,989. Many of these individual contributions are from David Merkowitz himself. Oh, but it gets better. This law firm that donates bigly to the politicians also happens to land several fat contracts to the tune of nearly $114,751,000. That's right, $115 million in contracts. There's an additional $6,150,000 in contracts that show up on a different page. They've pocketed a further $27,950,000 in expired contracts that began in 2006. The whopping total is $148,911,905. Let's just call it a cool $150 million. That's quite a return on their campaign contribution investments. But wait, there's more. This isn't the first pay-for-play instance where Kate Brown rewarded Markowitz Herbold law firm. She had just previous to the appointment of Jackie Kamens appointed another of the law firm's attorneys, Stephen Alexander, to a seat on the Multnomah County Circuit Court bench, unquote. Now do you see how the deck is stacked against the public? Oregon courts at both the state and federal levels are nothing but political appointees, most of whom owe a debt to or are friends with Oregon politicians and the law firms they came from. These judges suck at the public teat with their bloated salaries and benefits while they judicially rape the public in the courtroom in favor of their political and legal sponsors and the corporations they represent. There is no justice or constitutional rights in Oregon as a result of the criminal racketeering and conspiracy occurring between government, favored corporations, powerful legal firms, and the politically appointed and controlled court judges. I'd like to know where the $150 million in state contracts went that were awarded to the Markowitz-Herbold law firm. I'm very suspicious that a good portion of that money ended up offshore in Oregon Democratic politicians' shell company accounts. In addition, how many people can actually afford a lawyer? It's hard enough to get justice, but with no money it's impossible. The judges ignore those willing to educate and represent themselves pro se in court. It isn't easy going it alone, because the justice system is nothing more than ridiculous rules that without a lawyer are difficult to maneuver through and understand. Whistleblower states he had evidence of Agate Resources offshore accounts, but it was stolen by Marianne Dugan and given to Stoll Reeves attorneys. Politicians take campaign contributions from companies who receive state contracts. The amount donated to politicians seems so small compared to the amount of state contracts they hand out. Now, why would politicians take such a risk for such little financial gain? Certainly makes me suspicious of alternate payback mechanisms, such as offshore accounts. Now you have no excuses for not addressing these problems. If you do nothing, you put yourself, family, friends, and the entire lot of us at substantial risk.